This is a paid presentation of Martha Patterson, Certified Specialist in Estate Planning, Trust and Probate Law, Certified Elder Law Attorney by the National Elder Law Foundation. ElderLawMom.com, 855-ELDER-77. She is solely responsible for the content.
I'm attorney Martha Patterson, and I'm here to discuss what happens with your inheritance, wills, trust, probate.
Let's talk about wills. Is there such a thing as a simple will?
Well, there is a simple will, but a simple will is I give everything to my husband or wife when I pass away and then my kids. And that's all it says. And that's simple. Unfortunately, most people do not have simple families.
We don't have simple families anymore. No, we have multiple marriages. We have stepchildren. We have children we don't like.
We do, and so most people don't really want a simple will. They think they do. They think their situation is simple, but it's usually more complex, and most people don't realize the sad truth about wills is if you have a home, your property is going to end up in probate court.
Let's talk about the concept of a simple will, first of all.
Okay.
You can do it if you don't have property, if you don't have an extended family, if you don't have complications. And then, can you really do it yourself? Can you send off $25 for a form and fill in the blanks and do it yourself?
Well, you can. Unfortunately, you might fill the blanks out wrong, and that's the problem. You fill the blanks out wrong. If it's a form that really doesn't have the requirements, you could mess it really up, and you could do something really stupid like disinherit your own kids, leave out your husband. These fill in the blank forms are just way too simple. If you really want a simple will, the easiest thing to do is to get out a piece of paper and say, on this date I made my will, and you sign it and date it. Because you're going to write it like you really want it, and you write it like you're writing to a first grader.
You write your own letter.
Your own letter. And then, A, it's valid. B, you're not trying to fill in the blanks like somebody else thinks. You don't have any kids, and it says my children in the blanks, and it has all sorts of things that are one size fits all, but like clothes, one size doesn't fit all. That's all the fill in the blank forms are, that one size fits all. And we're not one size fits all. And so I don't recommend the blanks. I occasionally have somebody who really doesn't have much property. With kids, if you have minor children, it's really important for you to say, if you and your spouse are both gone, who you want to be the guardian. Because the judge isn't going to know. He's not going to know who you had in mind. He's not going to know that maybe somebody in your family is not appropriate. Put that down. If you handwrite it, that's great. Formal wills are always a little bit better, but I've helped out people who have really no assets, no money, and I'll sit them down and say, hey, this is free today. Here's your free will. Handwrite it, name your guardian for your kids. This is who I want to be the guardian of my kids. It's really, really important. It doesn't happen often that both parents die, but one of my saddest cases was both parents died and everybody fought over who was going to be guardian, because guess what, when you die, your kids get some Social Security money, and they equal money, and people might fight over them.
Really, people will actually fight over whatever money the kids get from Social Security.
They will. It's sad how much people fight over, money that shouldn't be important, but they do. People fight over the small money, and they'll want the kid for that check that comes with the kid.
Really?
Yeah, really.
Attorney Martha Patterson is offering you a free strategy session. Find out about wills, trusts, and other important documents. If you're facing a crisis, call now. Mention this program and you'll get $250 off any legal services after the free strategy session. 855-ELDER-77. 855-ELDER-77. When you sit down with a client, you're not really doing simple wills. You're looking at a lot of details. What are some of the concerns you have when you're writing up a will?
So when I'm writing up a will, the first thing is I'm looking at, do you have assets? Do you have enough that you really need to worry about probate court? Because if they do, then I'm going to say you really want that living trust. You don't want the will. You want a living trust, because then we're going to avoid probate, because probate's pretty expensive. If you have a $500,000 house, the probate fee is set by statute, so it's going to be $13,000 for the attorney, $13,000 for the executor, and then there's the costs of the court. So it's going to be around $2,000 for the court fees and the costs and all of the miscellaneous things you get to pay for in the probate process. And it's going to last 18 months or 2 years maybe. Could be longer, but that's the average is 18 months. So you want to keep out of the court. So that's what I'm looking for. I'm looking for second marriages. I'm looking for, do you have a developmentally disabled adult child or minor child, because we need a special plan for that special child of yours, because we don't want them to lose the public benefits that they will need to care for them throughout their life.
You must be looking also at savings accounts, pensions, investments, stocks, bonds.
Oh, absolutely. And in fact, there was a new law that was passed last year. It's called the Secure Act. I don't remember what Secure stands for, but basically what this act said is your pension, we used to be able to stretch it over your kid's life, and we could continue that great tax-free benefit of the IRAs for a whole nother generation. Under the Secure Act, we can only do that for 10 years. It's a huge change, really taxing those pensions. People don't know that, but we want to make sure and take care of your pension. How do we make sure and reduce the taxes that your kids are going to have to pay when they inherit that IRA, that 401k, that 403b? It's a kind of a big deal, but of course, we attorneys talk about it, but you're not talking about that at your dinner table. Nobody's thinking about the pension. And there's a big mistake people make with pensions, life insurance. They forget to name their beneficiaries. So they can have a great living trust, a great will, and there's no beneficiary named. We try to avoid, they have these trusts. They don't name the trust as beneficiary. They don't name beneficiaries. It goes to probate court.
That's amazing. You do all of this paperwork and you forget to write down who you want to get all the stuff?
Yeah, and then it ends up in probate court. And I have seen that so many times. And then with the house, you have this great living trust. I had one very wealthy family. It was a very sophisticated plan. They refinanced their over $1 million home, and guess what? When they died, it wasn't in their trust. We had to go to probate court on the house, and they had spent a lot of money on a very high-level law firm to this exotic tax planning, and we ended up in probate court. If you don't have your assets in your trust, when you die, they don't go with your trust.
Attorney Martha Patterson is offering you a free strategy session. Find out about wills, trusts, and other important documents. If you're facing a crisis, call now. Mention this program and you'll get $250 off any legal services after the free strategy session. 855-ELDER-77. 855-ELDER-77. If you draw up a trust and then years later you buy some expensive jewelry or you buy a second home or you buy an RV, you've got to update the trust to put all this stuff in there.
You do. You have to keep it up to date. You really have to make sure that it's up to date. You change, you get more assets. The laws change.
What's the biggest mistake people make when they write up a will?
The biggest mistake they make is not thinking about who they want to have in charge. Just naming automatically the oldest kid. The funniest one I ever saw was one that came to me, and they named the son. She'd been told that name your oldest child. Her son had been in and out of jail for years. He was, had troubles with drugs. He was in jail when she died, and he was tried to act. He had a jailhouse lawyer, and he actually filed the probate from jail because it was the oldest kid. So it's a big mistake. The other thing is having a will when you need a living trust. They don't know the difference between a will and a trust. So a will, only death; a trust, life and death.
What about people who lose their will or misplace the will? I have a story in my family about a rich uncle whose will got lost after he died, and the money ended up going to his sister, who he hated, instead of the people he loved.
Oh yeah, the magically disappearing will is a really known story. That story I have heard hundreds of thousands of times. And guess what? When you make a will, nobody has a copy. Now I keep copies of the documents I prepare. In the old days, lawyers used to keep all their originals. They had big storage rooms. I'm not sure that younger lawyers are doing that anymore because office space has gotten so expensive. But even so, who would know which lawyer had the will? There's no database, there's no way to know. People should have copies of your will. If you
And where should the copies be?
Well, I usually make sure that when I do an estate planning document, I usually ask my clients for permission. They have to give permission. I usually make sure that their family needs it. If we're disinheriting somebody specific, then I make sure that the person that we don't want to get it doesn't have access to it. That maybe the will is kept with the person we want to get the property. So if we have a sister and she's our only heir, but we want it to go to our nieces and nephews. So by law, she would be there. Maybe we give it to the responsible nephew. He has all our original documents. We pass away, he has them. Not, so they can't magically disappear. We have to think, where would we put them? There's no one answer, but we have to think, where should I have that document so it doesn't just, somebody doesn't come to my house and go, there's my will. It's going to disappear and not be there because I get the estate if it disappears.
There's some hanky-panky going on with wills, is what you're telling me.
There's lots of hanky-panky, yep. Hanky-panky and probate court is there, and the judge has no choice. You can say, I know that he had a will and it named so-and-so and so-and-so, but if he doesn't have it, he can't. He has to see that actual document.
Attorney Martha Patterson is offering you a free strategy session. Find out about wills, trusts, and other important documents. If you're facing a crisis, call now. Mention this program and you'll get $250 off any legal services after the free strategy session. 855-ELDER-77. 855-ELDER-77.
This is the Long-Term Care Minute.
According to the Alzheimer's Association, over 5 million Americans are living with Alzheimer's. Every 68 seconds, someone is diagnosed with Alzheimer's. And with the average cost of nursing home care approaching $9,000 monthly, what should somebody with Alzheimer's do to prepare? For some advice, we called on certified elder law attorney and best-selling author Martha Patterson. So Martha, what should people do?
Quite simply, there are little-known laws and techniques that allow you to create tax-free money to pay for long-term care. I discuss these options and more in my new book, You Are Not Alone, Living with Dementia, that I'd like to give you for free. Call now. The next 30 viewers receive a free copy of my book.
Call today to get your free copy of Martha's book, You're Not Alone, Living with Dementia. 855-ELDER-77. That's 855-ELDER-77. 855-ELDER-77.
You like living trusts better than wills. What goes into a living trust?
So a living trust is a much longer document than will. A living trust is designed to avoid probate. It says who gets your stuff when you die. It may have provisions to avoid estate taxes. It may set up even trusts for your kids when you're gone. So you might even say, hey, I've got, my kids are 4 and 6. Obviously, they're not going to get their money until they're 18 by law anyway. But you may want to, make sure that they're put through college. We can do that. We may want to. You may have a kid who's unlucky in marriage. You may want to set it up so that they, their inheritance is protected from their divorces. We can do that. You may have a developmentally disabled adult child or a special needs child, somebody who has other disabilities and they're getting public benefits. We can set up a special needs trust for them. All inside your trust. So we can say all these things when you pass on, when you die, are taken care of. So
does a living trust also say how you should be cared for when you can no longer make decisions about yourself?
Yes, that's a really important thing. So we really want to make sure how do we take care of you when you're alive. We can put in there that we don't want a nursing home. We can we can put that in there. We can also say, what happens if you become incapacitated? Who takes over for you? So now you're incapacitated with a will. The will doesn't tell the judge who takes over for you if you're, you've lost your mind. You can't remember your kids.
But the
You have
living trust
Alzheimer's.
does.
But living trust, does take over.
So what are some of the things that the living trust does while you're still alive? Some of the things it takes care of.
So to me, I really think it's important to talk about what happens in your life. Well, who's going to take care of you? Who's going to make your financial decisions in your life? It's a different job than when you're dead. When you're alive, you need somebody to pay for your care, to pay your bills, somebody who can
Manages your money.
manage your money and manage it for your life, manage it so it can pay for care. A much different job than just passing money to your kids.
Attorney Martha Patterson is offering you a free strategy session. Find out about wills, trusts, and other important documents. If you're facing a crisis, call now. Mention this program and you'll get $250 off any legal services after the free strategy session. 855-ELDER-77. 855-ELDER-77. Does the living trust say, I don't want to be on life support? Don't leave me on a machine?
We call them advanced health care directives. That's the formal name in California.
So that's not in the living trust.
It's not in living trust, and it's not in your will. It's actually a separate legal document.
And then it's called a...
It's called a living will or an advanced health care directive. Living will is still a term that people use. Those living wills, probably the most important legal document you ever have.
That's the advanced health care directive.
Right.
Do you do that with a lawyer?
So I'm a certified elder law attorney by the National Elder Law Foundation, and one of the things that elder law attorneys really focus on that estate planning attorneys don't is that healthcare directive, those healthcare decisions, making sure you do that. It is surprising to me how many times somebody comes in, maybe for their will or trust, with a halfway filled out advanced healthcare directive from Kaiser. Kaiser's really good about giving them to people. So, they come in and they're just stumped about, well, what decision do I make? The language that whoever wrote the statute is hard to understand. I understand it because I spent a lot of time reading it. It says, choice to prolong life, choice not to prolong life. What does that mean? And people don't understand what that means. It's not a simple, which box do I check? Well, what do you want? What do you want? You're laying in the hospital. Perhaps you have COVID and you're on a ventilator. Do you want to be kept on that for months? Do you not? People have opinions about that. Do you want to have artificial nutrition? Maybe do you want that? Do you not want that? Do you want to be kept alive? Some people do, some people don't. What about artificial hydration? Those are all decisions we have to discuss. So when they come in my office, we go through and we discuss what that means. I explain to them, I actually have way more than I think I should about artificial nutrition, hydration, ventilators, and how they work, and that whole process of end of life. I'm really passionate about helping people. I sometimes actually am just paid specifically for the healthcare directive and to help guide a family through a cancer diagnosis, and that. It's something I, specialize in.
So is it a good idea to talk to a lawyer about the advanced healthcare directive?
It is, but a lawyer who actually understands it, because I'm not sure everybody understands them. If you really have a passionate feeling about what you want at end of life, you really want to sit down with a lawyer, and yours may be the standard free one at Kaiser is very short. Yours may be much longer. Yours could be very detailed.
You could have a lot of details if you're inclined to have a lot of details.
Yeah, most of
My grandfather said, "You're going to keep me alive as long as possible."
Right. And if you want that, then we want to make sure that that is honored. Some people do want to be kept alive as long as possible. For some, that is a very closely held religious belief, and some people want to be kept alive. So we want to know that, because when you're 85, 90 years old, the doctors see you differently than when you're 20 years old.
He was 101.
Yeah.
He
Yeah.
didn't want to go anywhere.
He didn't want to go anywhere. He wanted all the life support. Well, we need to tell them, and we need to, in that directive, we need to choose somebody who's going to do your wishes. And it may or may not be your spouse. So I joke a lot of times with spouses is, a lot of my clients, as they're aging, they don't want to be kept alive. But their spouse, loves them and is going to want to keep them alive. So maybe they want to choose, one of their children.
So this takes the burden off of the spouse, doesn't it? Takes the burden off of the children and the grandchildren.
Right. When I have that written document and you're in the hospital and I've put together, your wishes, and they're saying the doctor says they want to put Dad on a ventilator. And he said, I don't want it under any circumstances. Well, now I have it in writing. I can call the hospital. I can talk to their bioethics team. I can say, my client said they didn't want it. What part of that don't you understand? You are legally obligated to follow their wishes, and you can't override them. Well, this is for a lot of people, this is a big deal. Now, to get that advocacy, that is something that people have to pay for, to have an advocate. Their family is the first advocate, but when it's a fight between the doctor, and the patient, and the family, if you want to be kept alive and the doctor's going, but we don't want to spend the money on you, we need an advocate. I did that. I had a family who called. They wanted to keep their loved one wanted to be kept alive. He was on ventilators, artificial food, hydration, everything. The doctors wanted to turn off the machines. We advocated for him to be kept alive. I've also advocated for people to be not kept alive. Sometimes medically there's not a whole lot of choices, but you need the advocacy over what your wishes. You need to know, but if I don't have them in writing, there's nothing I can do.
Attorney Martha Patterson is offering you a free strategy session. Find out about wills, trusts, and other important documents. If you're facing a crisis, call now. Mention this program and you'll get $250 off any legal services after the free strategy session. 855-ELDER-77. 855-ELDER-77.
This is the Long-Term Care Minute.
According to the Alzheimer's Association, over 5 million Americans are living with Alzheimer's. Every 68 seconds, someone is diagnosed with Alzheimer's. And with the average cost of nursing home care approaching $9,000 monthly, what should somebody with Alzheimer's do to prepare? For some advice, we called on certified elder law attorney and best-selling author Martha Patterson. So Martha, what should people do?
Quite simply, there are little-known laws and techniques that allow you to create tax-free money to pay for long-term care. I discuss these options and more in my new book, You Are Not Alone, Living with Dementia, that I'd like to give you for free. Call now. The next 30 viewers receive a free copy of my book.
Call today to get your free copy of Martha's book, You're Not Alone, Living with Dementia. 855-ELDER-77. That's 855-ELDER-77. 855-ELDER-77.
What are some of the things to do if your loved one did not have a will, did not have a trust? What do you do?
Well, this is when you really do need an attorney. You don't want to be muddling through the probate court by yourself. The process is not logical. There's lots of papers that have to be filled out. They have to be filled out on specific forms. If you don't do it right, then the court's going to say, come back and fix it.
You don't want to go to probate court.
You don't. We want to avoid it, because it's expensive and it's slow. It can take, everything takes months. The courts are very busy. They don't, on TV you walk in and you get their petition approved all in that same hour. Well, in real life, it's months and months and months. And, if you're having to pay the mortgage of your executor, of the decedent, you still have to pay that mortgage. You have to pay their bills, their electric bill. With what money? It may be your money, because guess what? That Social Security check, when you die, it's gone. In fact, the last check you get, they get it back.
That's because Social Security pays you a month in advance.
That is correct, and that is, I think, for a lot of people, the biggest surprise ever is all of a sudden Social Security's gobbled that money right back away. And now that they're doing automatic deposit, those automatic withdrawals are pretty fast.
Huh. And a lot of people don't know that Social Security pays you a month in advance. You die, that last check goes back to the government.
That's correct. Yeah, a lot of people don't know that. I think that comes as a surprise to people.
When a loved one dies and there is no will and there is no trust, what are some of the things you've got to do right away?
Okay, so the first thing you need to do right away, in my opinion, is, you've got to make the burial plans. The second thing you have to do is you have to secure the house. You want the house secured.
You don't want people walking in, taking out jewelry and art and furniture.
Right. So you've got to make sure the house is secure. You may need to change locks. Number 3, at this point, if you have no legal documents and they own property, then you're going to really want to call a lawyer and say, what do? We have no will, we have no trust, we have this property. We want to get into court immediately so we can legally secure the property, secure the bank accounts, make sure that somebody is not impersonating a dead person and going to the bank and clearing out the bank accounts. You actually want to get into court really quickly when you have no documents.
Martha Patterson, thank you very much. Attorney Martha Patterson is offering you a free strategy session. Find out about wills, trusts, and other important documents. If you're facing a crisis, call now. Mention this program and you'll get $250 off any legal services after the free strategy session. 855-ELDER-77. 855-ELDER-77. Call now. 855-ELDER-77.
This is the Long-Term Care Minute.
According to the Alzheimer's Association, over 5 million Americans are living with Alzheimer's. Every 68 seconds, someone is diagnosed with Alzheimer's. And with the average cost of nursing home care approaching $9,000 monthly, what should somebody with Alzheimer's do to prepare? For some advice, we called on certified elder law attorney and best-selling author Martha Patterson. So Martha, what should people do?
Quite simply, there are little-known laws and techniques that allow you to create tax-free money to pay for long-term care. I discuss these options and more in my new book, You Are Not Alone, Living with Dementia, that I'd like to give you for free. Call now. The next 30 viewers receive a free copy of my book.
Call today to get your free copy of Martha's book, You're Not Alone, Living with Dementia. 855-ELDER-77. That's 855-ELDER-77. 855-ELDER-77.
This was a paid presentation of Martha Patterson, California specialist in estate planning, trust, and probate law, certified elder law attorney by the National Elder Law Foundation, elderlawmom.com, 855-ELDER-77. She is solely responsible for the content.